Hi, everyone. This is Angie Cola-Maria, the Chief Legal Counsel with the Montana Department of Environmental Quality. Thanks for joining us at this lunchtime session. Today, we're going to be talking about the bills in the 2021 session that affected either directly or indirectly the Department of Environmental Quality. We're doing something fancy here with two screens, so I can see the chat. So if folks have questions, I will try to pay attention to the chat throughout, but I'll also try to end a little early so that if you have questions, I can answer those at the end. But apologies ahead of time if you ask a question while I'm talking and I don't notice it, because I'm not exactly technologically savvy. So hopefully this all goes well. All right. So moving to the first slide. Oh, it's already going wrong. There we go. Thank you. All right. All right. So just a general overview here. There were 1,313 bills introduced this past legislative session. We didn't count them exactly. I think I would say we identified about 200 maybe that were somehow applicable to DEQ. And it wasn't all at one time because some bills were introduced, some bills died throughout the session, et cetera. But there were a lot that we were tracking throughout the session. Of the bills that we were tracking, 86 of those were actually passed. Today, I'm not going to cover all 86. I'm going to talk about the more substantial bills, which are the bills that they're going to take a lot of time to implement or resources, or that substantially change DEQ's authority. So I think there's about 30 bills in my slides, and I'm not even going to have time to talk through all of those. So let's get started. The first, and I've grouped them into categories just for ease of organization. The first group is bills that apply to all agencies. For the most part, I'm not going to talk about those types of bills, like HR bills or bills that apply to all the agencies equally. However, there are a few that I wanted to point out because these are the few that will have the greatest impact on DEQ operations. If you've attended the other legislative update sessions this summer, you've probably seen some of these already come up. So I'm just going to give a very basic summary of those. The first one on the list is HB 358, the State's Settlement of Claims, Sunshine, and Transparency Act. The act requires any government entity that executes a settlement of $10,000 or more, and that's either money or something of monetary value of $10,000 or more, to publish specific information on a public settlement website. Department of Administration has created a ServiceNow form for agencies to fill out all the required information, and that's all listed in the statute. The law went into effect July 1st, and the information for each settlement is supposed to be published 60 days after the settlement is executed. So the first bits of information should have started going up at the end of August, which is 60 days after July 1st. The law is pretty broad. It requires any government entity to post this information: commission, a board, a hospital, university, you name it. It also requires agencies to file a quarterly report of any claims that we have pending against us for 10,000 or more. So not just things where we've settled, but any claims that we have pending against us have to go into that report. And I think that's about all I need to say about that, because I think everyone's probably pretty familiar with it. The next one on the list is HB 537, which revises venue laws. It revises venue laws for district court actions for a wide variety of different types of lawsuits. It goes through the entire MCA and removes Lewis and Clark County as an option for the jurisdiction in which to bring many, if not most, claims or cause of actions in the state. There's some exceptions, such as if the defendant doesn't have a residence or a business in Montana, but it's pretty comprehensive. So now, in a lot of cases, the suit must be brought in the district court of the county in which the claim arose, or if it's a violation, where the violation occurred. For DEQ, there are a lot of sections that were amended to take out the Lewis and Clark County option. For example, it amends Title 75, Chapter 5, Part 1, which is our water quality provisions to state that any challenge to an action taken by DEQ or to a decision issued by the Board of Environmental Review pursuant to this chapter must be brought in the district court in the county where the activity that is the subject of the challenge is supposed to occur. It makes similar deletions of the Lewis and Clark option through most of our enforcement provisions. So it changes it in the air quality section, public water supplies, solid waste, hazardous waste management, junk vehicles, remediation actions in the event of a hazardous release, septic disposal, on storage tanks, subdivisions, reclamation of mines, all the types of mines that we regulate, and MTBE. So since DEQ can no longer bring an action in Lewis and Clark County for violations under those acts, it's probably going to have some effect on our resources because we're going to need to pay for travel costs associated with the various personnel, obviously the attorneys, but DEQ employees, expert witnesses, if it's a Board of Environmental Review contested case, the BER attorneys. So that's just something we're going to have to keep an eye on for that. And I'm assuming other agencies are similarly situated. Next thing on the list is HB 447, generally revising laws related to legislative oversight. The big thing for us on this bill is that it prohibits rulemaking between October 1st and the end of the year prior to a regular session. So next year, next October will be an October that is prior to a regular session of the legislature. So between then and when the session starts, we will not be able to issue any rules, which is going to be important to keep in mind because we are likely to have a lot of rule changes over the next year as part of the governor's regulatory reform initiative, which I'll talk about at the end. And then the last thing on the list is the ARPA bill. This is ARPA bill was a federal bill, American Rescue Plan Act, that allocates certain federal funds to states, and HB 632 appropriates money to various state agencies. It also establishes advisory commissions within the state to implement the bill. We were heavily involved in implementing and are still implementing this act because our DEQ director, Chris Dorrington, has been appointed to the Infrastructure Advisory Commission. Water and sewer is critical throughout the bill. There's various sections that either directly or indirectly affect infrastructure and water and sewer. The bill says that the Department of Natural Resources and Conservation will be the lead in making recommendations to the advisory committee on which projects get the funds that are to be doled out. So DEQ was part of the team that helped evaluate those submissions with the DNRC. Earlier this month, they went through earlier this year, they went through a whole process to accept applications and review them based on various criteria, came up with recommendations, submitted that to the governor, and then a few weeks ago, he approved that first round of ARPA water and sewer infrastructure grants. It was, I think, about $147 million was awarded to 86 projects. And then there'll be a round 2 in January. And then let's see if I can switch. All right, so you should see the next screen. Hopefully someone chat if you do not see a new screen that says miscellaneous substantive bills. All right, so the next group is I've labeled it miscellaneous for lack of a better word, but it's just a random assortment of bills that touch some of our most basic programs, such as mining, water protection, and as it turns out, meth. So I'm covering this group first because it contains some of the more substantial DEQ related bills passed this legislative session. The first one on the list is SB 233, generally revised the Board of Environmental Review. For those of you unfamiliar with DEQ's organizational structure, we have a Board of Environmental Review, and it's administratively attached to DEQ. What that means is that its budget comes out of the DEQ budget, and DEQ provides administrative support to the board in the form of a board secretary, but for all other purposes, it's treated as a separate entity. For example, we follow ex parte rules when we have contested cases before the board that involve DEQ and a third party. So before SB 233, the board had 2 main roles. It acted as an appeals body for many DEQ decisions, like a permit appeal. but it also had separate statutory authority and duties to promulgate rules to implement several of our statutes. So there were BER rules, and then there were DEQ promulgated rules, just like any other agency has. The bill originally, when it was proposed at the beginning of the session, was a bill to dissolve the board completely and move everything into DEQ. The version that was passed only removes the rulemaking authority from BER and places it with DEQ. So now DEQ is doing all of the rules and the BER keeps the contested cases. The bill goes through the MCA and replaces wherever it mentions rulemaking duties of the BER, it changes it to DEQ. There's also a clause at the end that's helpful that states that rulemaking authority and existing rules under the jurisdiction of the board are transferred to the DEQ on the effective date of this act. So that just clears up any confusion about whether we needed to make any rule changes or anything before the change of authority was effective. In terms of impacts to DEQ, it actually isn't making a huge impact on our day-to-day operations, because even before this, whenever there was a BER rule that needed to be proposed, the DEQ would do most of the prep and the research and would actually come to the BER with a draft rule package, and then we would see it through completion. So the BER process was really similar to any of the MAPA rulemaking process that all agencies use for their own rules. So we'll now follow that process for all of the rules. So it hasn't had a huge impact on our time and resources. All right, the next one on the list is HB 599. HB 599 changed the law for issuing open cut mining permits and created a new type of permit for rural sites that is easier and quicker to get. Just we call them for high and dry sites that are not located within a half mile of existing occupied dwelling units. I'm not going to go through every section of the bill, but the three main substantive provisions are sections 3, 4, and 5. Section 3 says that except for in subsections 2 and 3, which I'll get to in a minute, a permit is required for operators that remove more than 10,000 cubic yards of materials, or that remove less than 10,000 cubic yards and are affecting water, and they've never had a permit before. So when we say less than 10,000 cubic yards and affects water, I mean affects surface water, which includes intermittent and perennial streams, groundwater, or water conveyance facilities, which are canals, irrigation ditches, that type of thing, anything intended to move water out to the fields. So that's when you need a permit. Then there's 2 exceptions in subsections 2 and 3. The first is if you already have a permit, you can conduct limited open cut operations, LOOs, without first getting an additional permit or amendment to your existing permit if you meet certain criteria, and those are spelled out in the statute. And then the second exception is operators who remove less than 10,000 cubic yards of material for personal or agricultural uses. You can do that without a permit, as long as it doesn't affect surface water, groundwater, or water conveyance facilities. There's other permit requirements and restrictions in that section. Namely, it allows operators to apply for permit amendments by filling out a form that DEQ created, and I'll talk about the forms in a minute. So that's section 3, telling you when a permit is required and when it's not. Section 4 talks about if you need a permit, these are the types of permits that you can apply for. The operations subject to a standard application process and public notice requirements include any operation that affects groundwater, surface water, water conveyance facilities, and there are 10 or more occupied dwelling units within a half mile of the permit boundary. So that's your standard permit. You'll go through all of the basic application process and public notice requirements, and those are listed in section 4. And then all other operations are subject to a new subsection 14. So this is a new section that creates a new type of permit, which DEQ has designated as a rural permit, which is very unfortunate because it's really hard to say, but that's what we're calling it. These operators for these types of permits have to submit the information listed in the statute, and we also summarized it in our DEQ forms. But it's basically saying you've done your public notice and your outreach, you have a reclamation bond, and a few other requirements. You have to submit that information to DEQ, and if we determine that the information is complete and acceptable, we'll notify the operator and then issue a rural permit. Otherwise, we would issue a deficiency letter outlining whatever's missing. If you are reading the statute, you'll notice that it's in this section, it talks about we give a notice. It doesn't say permit, but we're still calling it a permit just for ease of comparison with a standard permit. The difference is that the rural permit application is much more streamlined than the standard permit application. For example, it doesn't have the water resources assessment that's required in other permits. This section also changes the public meeting threshold criteria for when you have to have a public meeting for a proposed project. So the department accepts public comment for both the standard and the rural permit throughout the review process. But now we have to, and we will, hold a public meeting in the area of the proposed open cut operation, either at the request of the applicant or if at least 51% of the real property owners on which occupied dwelling units exist ask for it, or if 10 real property owners with dwelling units request it, whichever is greater. So 51% or 10 people if they request it. That used to be 30% and 10 property owners. They didn't have to have dwellings on it, just regular property owners. So it's increased that threshold a little. And then the last section is section 5 that I'm going to talk about, which outlines the plan of operation and what needs to be included in order for it to be acceptable in terms of DEQ acceptability determination. There were significant changes to this section for water, noise and visual impacts, hours of operation, structures, improvements. This is, I think, where some of the more substantial changes to the existing statute took place. And then at the end, section 9 contains a very unique retroactivity provision. So section 3 covers when a permit's required and what it must contain. Section 5 covers the plan of operation and what that must contain. The retroactivity provision says that sections 3 and 5 apply retroactively to amendments for open cut operations in existence on the effective date of this act that propose to change the reclamation date or the post-mine land use. So we're interpreting that to mean that if an open cut operation were in existence on the effective date and the operators propose amendments to either change the reclamation date or the post-mine land use, then sections 3 and 5 apply retroactively. Not the whole statute, just sections 3 and 5. So that means that if you had an operator that they could propose a handful of changes to their existing permit, one of which is a change in reclamation date or change in post-mine land use, then they would get all of the changed requirements under sections 3 and 5. But because it's an amendment and not a new permit, they wouldn't have to go through the public notice and public meeting requirements of section 4. HB 599 also required the department to create specific forms to change the reclamation date and the post-mine land use date, as well as obviously new application forms for the standard and rural permits. So we've created those. They're up on our website under the open cut mining section. Also, just since passage of HB 599, we've conducted extensive stakeholder outreach to try to provide a smooth transition to these new statutory frameworks for permits, convey our interpretation of the law, because there's a lot of, I would say, vague or confusing language in the law, and just to be able to answer questions from interested parties. We've had several of those meetings, or just informal or formal, and if anyone's interested in more information, there is an open cut stakeholders meeting tomorrow, Thursday, the 16th, from 1 to 4. You can contact the DEQ Open Cut program for more information on how to attend either in person or by Zoom. And I think somewhere in these materials is my contact information. You can also just contact me and I can give you the information on how to join that. Okay, next on the list, SB 284. This is just a simple law that exempts county, cities, towns from having to pay certain fees associated with open cut mining permits. They're already exempt from most open cut fees and the bond requirements under the Open Cut Mining Act, but there's also a fee that you have to submit with your annual report, and this just exempts them from that. HJ 37, next on the list, is a study of Lake Koocanusa selenium standard. First of all, does anyone know where Lake Koocanusa came? This is just a fun fact I learned as part of this process. It is on the Kootenai River, and it's at the border of Canada and the USA, USA. So Koocanusa. I guess it was a contest that Montana had a while ago, and that's how it was named. Anyway, I digress. So at the end of last year, the Board of Environmental Review adopted a site-specific selenium standard for Lake Bay up on the border. This is a good example of a BER rule where DEQ was heavily involved in its promulgation. We held stakeholder meetings over the course of several years. We worked with Canadian authorities as well as US experts such as USGS, and then we crafted a rule to present to the BER for them to adopt. So HJ 37, it's a joint resolution asking for an interim study of the Lake Bay selenium standard that was adopted in December of 2020. DEQ and the Environmental Quality Council are supposed to collaborate with listed stakeholders to complete a study by April 1st of next year. The study is supposed to analyze the data and the processes referenced in and used to support the rulemaking to determine if it complies with the Montana Water Quality Act and the Federal Clean Water Act, and then offer recommendations on what changes, if any, need to be made to the rule or the supporting documentation. And I'll just note that this was actually related or tangentially related to another bill, SB 324, it was introduced this session, but it was not passed to this session. That bill would have actually repealed the selenium rules outright. And then this, I don't know if this was a compromise or just coincidental, but this is what got passed to just the study bill. And switching to the next screen, let me know if you don't see anything new, is SB 358, repeal the numeric nutrient standards for water quality. We could have a 2-day seminar just on numeric nutrient standards. So I'm going to just try to cover this very high level. In terms of background, long ago, DEQ identified nutrients in water as a source of impairment to state waters. We originally had a narrative nutrient standard in place, but beginning in the late 90s, we began working on water body specific numeric nutrient criteria as opposed to the narrative criteria. And we actually started with the Clark Fork River. We worked with the statewide nutrient work group and the Board of Environmental Review, and we passed those more comprehensive statewide numeric nutrient criteria, as well as a general variance from those criteria in 2014. Those covered most state waters except for lakes, reservoirs, and some of the largest rivers. These new standards were adopted as DEQ circulars 12A and 12B. So those have been in place for a few years, and as you might guess, they are currently the subject of multiple litigation matters in both state and federal court, which unfortunately we don't have time today to go into all the different court cases on those. Needless to say, they have been controversial. So SB, yeah.
The numeric, I get so many parts per million.
Right. Right. And so the reason we changed this is because narrative standards are very hard to implement because there's not like a typical example. Yeah, there's not a typical example. It's you're looking at the effect of each individual project or input on the whatever water body you're talking about, because it's also water body specific, and looking at the impacts of that. And so it's hard to have consistency when you're working through a narrative standard like that. Whereas if you just got a number that you can point to, then it's a lot easier. So back to SB 358, it became law on April 30th of this year. The basic purpose is to eliminate the current numeric nutrient standards in the regulatory scheme, revert back to the narrative standards, and then create a new set of rules for translating those narrative standards. So maybe they are easier to implement and to understand, based on an adaptive management philosophy. It doesn't really describe or provide criteria for what they mean by adaptive management philosophy. So we're working on that. But it requires DEQ and the Board of Environmental Review to amend the state administrative rules, delete all references to circulars DEQ 12A and 12B, which are the numeric standards. It immediately repeals the general nutrient standards in 12B and all the related rules, and then directs DEQ to repeal the 12A numeric nutrient criteria. We haven't done that yet, but we're in the process of doing so. Since SB 233 kind of transferred all of the BER's relevant rulemaking authority to DEQ, we'll be taking lead on conducting the necessary rulemaking to repeal that 12A numeric nutrient criteria. It also directs us to adopt new rules related to the implementation of the narrative standards by March of next year. We've been engaging with the nutrient work group to assist in implementing those new provisions and to adopt the new narrative interpretation / adaptive management rules by March 1st. We're also planning to do the 12A repeal at the same time. We've had frequent meetings, they're still ongoing. I would say the process needs to be complete by November in order to have a final rule by March, just realistically speaking. So we're continuing full force ahead on that. Complicating the matter, and again, we could talk all day about these issues, but I think this group might find it interesting that the federal EPA needs to approve all of our state standards under the Federal Clean Water Act. To date, EPA's opinion is that numeric nutrient standards are still in place for purposes of federal law until EPA approves any changes under the Clean Water Act. So in the interim, before the new rules are adopted, the law directs DEQ to apply narrative standards to all of the MPDES permits, not DEQ 12A. But that creates an additional challenge because EPA has not approved a reversion back to our narrative standards. So arguably, DEQ 12A remains the effective water quality standard for federal clean water purposes unless EPA approves the change. So that's created lots of brain time for our water attorneys, and they've spent a lot of time working with the nutrient working group and EPA and try to kind of untangle that. So like I said, we could talk forever about just SB 358, but I want to make sure we can get through a few other bills too today. So moving to SB 53, this bill modifies the Metal Mine Reclamation Act for the regulation of certain rock products. It clarifies the definition of rock products to only include rocks that are collected from or just below the ground surface that don't contain sulfides with the potential to produce acid, toxic, or other pollutive solutions. So these are your decorative rocks, basically. The idea there, according to the preamble of the rule, is that, or of the statute, is that those types of rocks deserve less stringent environmental review and less stringent administrative burden. It then lays out a streamlined application and operating permit process for those types of rock products. And then it exempts those types of permits from MEPA review, the Montana Environmental Protection Act. If it's an application for a new permit resulting in less than 15 acres of total disturbance, or an application to amend a permit for less than 15 acres, or an application to amend a permit that has already been analyzed under MEPA that results in less than 25 acres of new disturbance. So it, for some minor types of disturbance, it exempts them from having MEPA review. And then the next one on the list is HB 116, indoor cleanup standards for methamphetamine. This is, I guess when I first arrived at DEQ a couple of years ago, I didn't realize what a big role we actually played in meth regulation. But under the current program, before this bill, if an owner of an inhabitable property knows the property has been used as a meth lab, the owner has to notify any subsequent purchaser or occupant if the property hasn't been remediated to certain standards by a certified contractor. They may also provide notice that it has been remediated. And if they do provide notice that it's been remediated and DEQ confirms that it's been remediated to certain standards, it's good, then the owner won't be liable in any action brought by a person, subsequent owner or what have you, based on the presence of meth in that property. So that's the existing program. HB 116 just expands that requirement to include not just previous meth labs, but also property that has been contaminated from smoke from the use of meth. It also raises the decontamination standards from 0.1 micrograms per 100 square centimeters to 1.5 micrograms. Last on the list is SB 348, which involves snowmaking. I won't go into a lot of detail with this because it simply codifies existing rules into statute. It requires DEQ to provide a written response within 60 days to an applicant seeking approval for the use of reclaimed wastewater for snowmaking. By snowmaking, I mean on a ski resort or what have you. They have the snowmaking machines. A lot of places use reclaimed wastewater to make that snow. So that's all I'm going to really cover on 358, just in the interest of time. So those are the random assortment of bills. Now we'll talk about some specific categories of bills. First on the list is subdivisions. Early in the session, I was surprised how many bills were introduced that dealt with subdivisions. I didn't really think that was that much of a controversial issue, but I guess when you think about it, as the state population expands and people are building more and more houses in more and more previously undisturbed areas, it's bound to create some interest either from the developers who want to ease restrictions or neighbors who might want to increase restrictions, cities and municipalities that have to regulate or approve those new subdivisions, just numerous other interested parties. So it has been a hot topic this legislative session. And I'm not going to go through all of the subdivision bills, but I do want to go into a little detail on SB 44. This was actually an agency-sponsored bill. Since 2017, DEQ has been working to make the subdivision review process under the Sanitations and Subdivisions Act more transparent, more efficient, but also just maintaining the public health and environment protections as well. SB 44 just continues that progress. It clarifies a few things. We worked with the Subdivision and Development Advisory Council for many months with the goal of providing additional clarity. We had 5 goals in introducing SB 44. The first one was just to clean up provisions that clarify what is a subdivision. We spent a ridiculous amount of time dealing with that, just the legal interpretation of that under the existing statute. So for the purposes of the review of the water, the wastewater, and stormwater throughout the act, that was a really key provision to have. The second goal is to ensure that property protections that were established in 2011 and 2013 amendments apply to all new lots created under the act, including those that utilize the no facilities exclusion at the time they are created. The no facilities exclusion, I think, is an interesting story for why these changes were needed. The exemption, the no facilities exemption, is where someone is creating a lot that ordinarily would be considered a subdivision and reviewed as such, but they aren't putting any wastewater or water treatment facilities on it. So they can claim an exemption from review. So they don't have to be reviewed as a subdivision. Otherwise, every lot normally has to be reviewed before filing the plat. The statute says that a draining field, mixing zone, and a well isolation zone in any proposed subdivision has to stay within the property borders. So if you got these zones, you got to stay within your property borders. You can't have them be flooding into your neighbor's property. But what people were doing was they would create a subdivision, and get it approved. So it existed, because the statute says that you can't have those zones in any proposed subdivision outside of your border. So they would get the subdivision so that it existed, it wasn't proposed. And on the plat, they would put no facilities. So they would qualify for the exemption, the no facilities exemption. So they didn't need review. So they had a subdivision. It didn't have to have review because they didn't have facilities on it. And then it's existing. So then they came back later, once it was existing, and said, now we want a review, but we're no longer a proposed subdivision. So our mixing zones can go outside of the boundaries. That was just a huge loophole that needed to be fixed. And this HB 44 has provisions that explicitly state that that is not what you're supposed to do. They apply even if you had an existing facility that had no, or existing plot that had no facilities on it. The next goal that we were shooting for with this act is incentivizing local reviews for subdivisions by allowing counties to cover the cost of their reviews through locally adopted fees. We also wanted to provide clear notification to buyers who purchase the property that has not yet been reviewed for the water, the wastewater, stormwater under the act. The idea there is to help to ensure that buyers are not surprised after they purchase property that still needs to be reviewed before it can be developed. We've had a few cases where people come to us and had purchased properties and hadn't been reviewed, and then they come to DEQ and we can't actually approve them for what they want to do on the act. And they didn't know that there was restrictions on it. We also wanted to expand the use of exemptions in order to reduce the number of unnecessary reviews. So those were our goals in introducing the bill, but then in addition, as the bill proceeded through the legislative process, they added an amendment to the Subdivisions Act, which requires the department to adopt rules that provide a basis for not requiring stormwater review for parcels 5 acres or larger, on which the total impervious area does not and will not exceed 5%. So before this amendment, the stormwater review is required for all subdivisions subject to the act. And this amendment exempts the larger lots that have little impervious area from those stormwater requirements, since they have a larger or much less risk of stormwater runoff. When I say impervious area, I mean driveways, rooftops, things that are not going to allow water to soak into the soil. So if you just think maybe a 10-acre rural lot with a single home, it'll have just like a little driveway. Maybe it's not even paved. That's got less than 5% of their surface is impermeable. Since the end of the legislative session, DEQ has been traveling throughout the state to have community meetings to discuss upcoming rule revisions, not just for this bill, but also to discuss our comprehensive regulatory review initiative, and also hear feedback on another bill that was introduced this year, but was ultimately vetoed by the governor. But it did garner a lot of questions and identified some issues that need to be addressed. So I've actually included it on the list below this, SB 165. So again, SB 165 did not become law. It was vetoed by the governor. It proposed a number of changes to the Sanitation Act, including changes to DEQ rulemaking and review authority for septic systems, limitations on non-degradation review, and new exclusions for stormwater review. The bill passed legislature, but the governor vetoed it. And in his memo, he noted that the bill attempted to address some subdivision review issues without consideration of how those changes affect other regulatory requirements. He also highlighted the fact that it could have unintended consequences and negative impacts to private property. So since then, the department's been meeting with stakeholders across the state to find common themes and issues that can be improved through the rulemaking process, between now and the next legislative session. So that's 165. We can kind of go quickly through the rest of these. HB 444 would require DEQ to reissue old certificates of subdivision approval, or COSAs, under a very specific circumstance. So I actually included this on this list, not because it's a substantial bill for DEQ, but just in case someone just maybe skimmed HB 444 and thought, hey, it creates some new exemption from review that could possibly be available. It does amend the Sanitations and Subdivisions Act to add a procedure for reissuing a COSA without further review. However, in reality, the circumstances under which the circumstances that would be covered by this amendment are so specific, it's unlikely they would actually apply to many or if any future scenarios. It has to be, you can get this exemption, but it has to be for a lot divided and approved before 1973, that was then divided again, but without approval before 1973, then was never developed, and then was reaggregated to return to the original parcel as originally approved with the original lot dimensions and conditions. So this is more just there for folks to know it's probably not going to be an exemption that's widely used. And then I have a few more on this act because it's 1241. I'm just going to leave this here on the slides. We don't really need to go into detail on them. They're mostly just dealing indirectly with the subdivision approval process, but not necessarily DEQ specifically. So let's go to the next category, which are energy bills. Not surprisingly, there were several energy bills this session. I'll just kind of go into detail on the ones that were more directly related to DEQ or directly affected us. HB 273 is the first one. It removes nuclear facilities from the definition of facility for the purposes of the Montana Major Facility Siting Act, or MIFSA. So under MIFSA, we do several different types of reviews, including environmental review, and we give a certificate to projects that are listed as covered facilities. So under MIFSA, covered facilities, they're identified in the definition section, which is further modified to include nuclear facilities. So right now, or before the bill, nuclear facilities were covered facilities. The bill removes them from that definition of facility. So they'd no longer need DEQ MIFSA review and certification before construction. And I guess just practically what that means is they'd have reduced requirements to consult with neighboring landowners. And I'm going to tell you all these, but then there's a big if or a big but at the end. But just by being removed from MIFSA, you're going to have less requirements to consult with neighboring landowners, reduces our ability to require that adverse environmental impacts would be minimized, just removes some of the public participation parts, eliminates our ability to condition approval on a modification of the location of the facility. We would no longer be able to require an applicant to post reclamation bonds. And okay, so those are the practical implications of what happens if you're removing something from MIFSA. They also removed the provision that said that we cannot issue a certificate of compliance under MIFSA for a nuclear facility until the recommendation is approved by a majority of the voters in a statewide election called by initiative or referendum, according to the laws of the state. So this provision actually got a lot of discussion during the hearings to this bill, the removal of that referendum for voters to vote on a nuclear facility. But this only applied if DEQ were going to issue a certificate of compliance. If we went through the MIFSA review and we were going to issue a certificate of compliance, then the voting part would kick in. So because we're removing the certificate of compliance for nuclear facilities with these amendments, this referendum will never happen because we're never going to be coming to the voters with anything under these amendments. So the bill just goes through the MCA and removes all the provisions that deal with nuclear facilities and under MIFSA and what's required of them. I think those are the big provisions, but so here's my big but. There's other provisions and other protections that may still apply to nuclear facilities. The big one is the Federal Nuclear Regulatory Commission, currently still has oversight over the licensing and monitoring of a nuclear facility. And so they go through a very comprehensive environmental review process for all of their facilities. And then in terms of DEQ, we might still review nuclear facilities under MEPA, the Montana Environmental Protection Act, or Environmental Policy Act, for other permits that might be associated with the nuclear facility, like a wastewater, stormwater prevention permit, easements to cross state highways, that type of thing. So the MEPA review might still get attached to a nuclear facility, and MEPA, as you probably know, has a lot of public participation, public comment opportunities as well. It just would depend on the specific facility. So that, the basics on that. Next on the list is SJ3. This is a feasibility study, again, not for nuclear reactors. It's just a resolution that requests the Legislative Council designate a committee to study the feasibility of nuclear power generation, just to see if there are any Montana regulations that need to be revised in order to enable the construction of advanced nuclear reactors in the state. Also looking at the economic feasibility of replacing coal-fired boilers with advanced nuclear reactors. And then looking at safety. And for that, the study specifically says that you have to evaluate the safety of and waste stream resulting from the construction and operation of advanced nuclear reactors and gather input from residents of the coal strip area. And we'll talk about coal strip in a minute, but there's a coal-fired electric generating facility there that clearly the drafters of this legislation wanted to make sure that they were consulted. The study has to be done by September 15th, 2020, and then the results reported to the 68th legislature, which is the next legislature. And I'm going to try to go quickly through these next few. HB 170 is just a new tax classification for hydrogen. Moving to the next slide. Okay, so 576. This one I have on here because it repeals the Montana Renewable Power Production and Rural Economic Development Act, which is the Renewable Portfolio Standard. And it is the next two, SB 237 and HB 476, are related to this, but there are provisions in both of those bills that say if both Senate Bill 237 and 576 are passed, then 237 or 475 are void. So both of these bills, I put them on the list because they covered these issues, but they are now both void, even though they passed, because they both say if 576 also passed, then they're void. So right now we just have the repeal of the Renewable Portfolio Standard. All right, next group is electric generating facilities. There are a handful of these bills that deal with various rates and other tax consequences, et cetera, which I'm not going to go into, also just because it's way above my understanding, some of it. But it's interesting, a lot of the bills that regulate electric generating facilities this session, the way most of them are defined, the way they defined electric generating facility means that coal strip is the only or one of the only plants that would actually meet that definition of electric generating facility. So coal strip got a lot of attention this session. And for those of you just who aren't familiar with the coal strip steam electric station, it's a coal-fired generating facility. It had 4 units. 2 have been retired. I think they retired in January 2020. Units 3 and 4 are still operating and have about 740 megawatts of generating capacity each. So that's coal strip. The bills that I want to talk through. SB 87 is the first one. Requires any coal-fired generating unit to submit a water feasibility study to the DEQ before November 1st, 2022, and have to include that study in the reclamation plan for the facility. So it defines coal-fired generating units as having a generating capacity greater than or equal to 200 megawatts. The costs of completing the study have to be shared among the owners. And if there are multiple owners, it's just based on their individual ownership interest in the unit. The study has to include planning to ensure a local government attendant to a unit is able to access the local government's water rights and related infrastructure in the plant if the plant closes. An estimation of the potential conveyance costs that could be incurred by a local government for up to 30 years, and recommendations developed in consultation with the local community for meeting financial obligations necessary to ensure the affected local government is able to maintain its water supply and water rights. So the big concern with this bill obviously was water rights, which is actually more of a DNRC, Department of Natural Resources and Conservation issue than DEQ, but the study is to be submitted with us, and we'll at least be looking at that study as part of our review of the remediation plan. We do review the remediation plan for these facilities, and the study has to be part of that. The next ones are, they're very, because it's 1252, I'm just going to kind of skim over these really quickly. These indirectly affect Montana. SB 265 just invalidates venue agreements pertaining to electric generating facilities if the venue is not Montana. Clearly, the intent appears to be centered on making sure potential arbitration of dispute between owners occurs in Montana. Would also apply to Colstrip. SB 266 revise unfair trade to include certain actions related to electric generation. HB 647. This bill actually has tasks. I need to go to the next screen, sorry. There you go, HB 648. This actually has tasks for several different agencies throughout the bill, but for DEQ, it assigns us the duty to establish guidelines to compare costs and benefits of continued disposal of coal combustion residues at electric generation facilities versus economical ways to reuse the coal combustion residues. Includes guidelines for determining when a cost-benefit analysis is appropriate. It also amends MIFSA, the Major Facility Siting Act, to no longer require an electric generating facility of 250 megawatts or more to amend its certificate if all it's doing is changing its fuel source. And there are criteria that go along with that, but I think that's about all that we need to cover. I've got the rest of these in here, so you can look them up, but these are all pretty indirect to DEQ. So I don't think we need to cover those in detail. I do want to just be able to talk really quickly next steps. Obviously, a lot of these statutes are, they don't need to have rules. We've been implementing and we are going to be implementing them immediately. Some of them are going to require us to go through rulemaking in order to fully implement them. And so we've started that process. And then I just wanted to mention the comprehensive regulatory review. In addition to just any rules that need to be created because of statutes in the 2021 session, the agency is going through a review of all of our rules where we are going in several stages. We just finished a phase where we identify all of the statutes and regulations that apply to DEQ. We then assigned them each statute or each regulation to a program in DEQ. The water program deals with the water statutes, et cetera. And now we are going through, we've identified criteria that we're going to use, and we are prioritizing all of those rules to determine which ones need to be updated, changed, clarified, et cetera. And that'll go through early next year. And then we will then come up with a plan for how to actually start those rulemaking procedures to make those modifications. And the idea is to create efficiencies, reduce redundancies, and just make things more clear for the stakeholders and regulated community as well. So we're going to probably have a lot of rulemaking going on over the next year or two, which is why October 1st is an important date, because we kind of get cut off after that, because it's going to be the October before a legislative session. So that is it. I think the slides will be available. So for the bills I didn't have time to talk through, you can at least look those up in your free time. Are there any questions? And I'll also look at the chat too.
You mentioned lawsuits earlier. Are there any that could potentially like stop or invalidate all this rulemaking that you have to do currently?
I mean, I think the nutrients are probably numeric nutrient standards are probably a likely candidate of that. I think depending on how we implement some of these, we could get lawsuits. You know, on open cut, for example, it's gotten a lot of attention from developers and operators, as well as citizen groups, environmental groups. So that's a potential conflict point there. I mean, I think that's always a risk, obviously, but in terms of actual litigation right now, it's the numeric nutrient standards. I think that it's the big candidate there, depending on how that plays out in Montana District Courts or the Ninth Circuit. That could change things.
Like you said,
No, yeah, we're due in March. Okay.
great, well, thank you.
Yep, no problem.
Thank you.